for lunch. The defense had announced arrest. What we'll do, we'll bring the jury back in and allow you to announce that in their presence, and we'll go from there. First, does the defense have a motion?
Yes, sir. So we would move for a judgment of acquittal again. Your Honor, we would renew that motion. No reasonable jury would be able to find Ms. Jewell guilty of count 1, 2, or 3 after the close of our evidence. First, with culpable negligence, just pointing out the jury instruction language. It says if there's a violation of that duty, referring to the duty of care everyone owes to each other, without any conscious intent to harm, that violation is negligence, it's not culpable negligence. During the state's case and our case, no evidence has been presented that this was a conscious intention to harm Ariya. So culpable negligence has not been proven. I know that the state previously cited Taylor v. State and Leet v. State in their last argument for against this motion. In Taylor v. State, it's a woman who tested positive for meth in the hospital. She was instructed not to sleep with the baby in the bed with her. She knew that she was a heavy sleeper when she used meth. She used meth the night the decedent passed away. She also chose to sleep in the bed with that child knowing that she was a heavy sleeper. She woke up throughout the night, never checked on the child, and the child was dead. That shows conscious intention right there. Similarly, Leet v. State, similar facts. The defendant was dating a mother of a child. The defendant knew that there was an open DCF case against the mother for beating the child. He repeatedly saw signs of abuse, made the conscious decision to ignore those signs of abuse and not report them. And that's another conscious choice there. The jury instruction indicates consciousness or intention is required. The state has presented no evidence to support that this was a conscious decision with the intention of harming Ariya. So for those reasons, count 1 has not been proven, and we would ask for a judgment of acquittal on that. Turning to the felony murder, count 2, I know the state took issue with me referencing the New York felony murder statute. That is part of the analysis of the Florida Supreme Court case I previously mentioned, Studevant. And that case really talks about the difference between enumerated and unenumerated predicates for felony murder. And that case was dealing with an aggravated child abuse, right? But that is enumerated within the statute. And the court determined that because it's enumerated, and it was just one single act, but because it was enumerated, it doesn't matter that it's wholly subsumed into the felony murder. It can provide a predicate in and of itself, and they can be convicted of both. Comparatively, the court discusses when crimes are unenumerated, and if the harm is directly tied to the crime as an element of the crime, that is not an appropriate predicate there. This crime is unenumerated. It would fall under the last subsection without an intent to do harm. And our position, which is supported by the holding in Studevant by inference, is that this predicate is not an appropriate predicate for felony murder. Additionally, there are concerns the court needs to be aware of with this predicate, as the court has determined that there is no mens rea associated with this crime. When the Supreme Court evaluated the constitutional nature of the felony murder statute, they decided that because the intention from the predicate felony transfers to the felony murder, then that satisfies the jurisprudence surrounding there needing to be an intent for murder. And there is no intent or mens rea at all based on this court's ruling. So there is no mens rea to transfer. So for that reason, In addition to the one I previously mentioned, this is not an appropriate predicate for a crime, for felony murder rather, and as such, the court should enter a judgment of acquittal for felony murder. Lastly, we would still assert that knowledge is an essential element of the predicate crime, and there's been no evidence presented that indicated that Ms. Jewell knowingly left the child in the vehicle. So for those reasons, we'd also ask for a judgment of acquittal on that.
Okay. State wish to respond?
Very briefly, Your Honor, if I may. Your Honor, the state has put forth evidence that, taken in the light most favorable to the state, as a prima facie showing that a reasonable jury could find the defendant guilty. The state would renew all of its previous arguments made at the first judgment of acquittal, and now there's additional evidence that was put on during the defense's case. So beyond where we were the first time this argument was made, we also had the defendant's own testimony in addition to other evidence. If the legislature had designed or intended to preclude certain felonies, it would have written a statute to that light. So based on the previous arguments, the additional evidence before the court at this juncture, the state would request the denial of the judgment of acquittal.
Morning, John.
Yeah, I would just point out that there has been no evidence that this was a conscious act whatsoever. And the state's argument didn't highlight any of that. When we would stand on our other arguments.
Okay, I'm going to deny your motion for judgment of acquittal at this time. I still believe that these are questions for the jury to decide. Are we ready for the jury at this time?
Yes, Your Honor.
Okay, what we're going to do when we bring them in, I'll ask, or the defense can announce it's resting, and then at that point, we will move into a closing argument. Bring them in, please.
All right.
Talk about tea.
All jurors present.
Good.